Get ready for the dictation in 3, 2, 1, start. By this petition, under Section 34 of the Arbitration and Conciliation Act 1996, the petitioner challenges the award dated 7/12/2009 passed by the sole arbitrator, declining the claim of the petitioner for a grant of increased prices of bitumen used in the work performed under the subject contract. The contracted work in question awarded to the petitioner by the respondent was of strengthening and post-strengthening development works for main road number 56, strengthening of main carriageway and raising of footpath and improvement of central verge. By the impugned award, the arbitrator has dismissed the claim of the petitioner for reimbursement. The arbitrator has taken the view that when oil marketing companies increased the cost of bitumen, the same cannot be said to be on account of subsequent legislation or equivalent order, thereby entitling the petitioner to the benefit of Clause 10C of the contract. Mr. Sandeep Sethi, learned senior counsel for the petitioner, drew my attention to the said Clause 10C to contend that the same has been wrongly understood by the arbitrator. Para. The issue before the arbitrator was and before this court is the interpretation to be put on the expression any fresh law or statutory rule or order. The arbitrator, as already stated above, has held that increased price of bitumen by the oil companies cannot be construed to be an increase under the expression a statutory order. The language of the aforesaid expression used in clause 10C of the contract is quite clear that reimbursement of the contractor is for any increased cost of material or labor when the same is on account of any increase as a result of an order which has a statutory and legislative flavor, meaning thereby when the input cost to the contractor increases only because of any statute or ordinance or statutory rule or statutory order, only then in such circumstances the contractor can claim reimbursement for the higher cost incurred by it. In my opinion, the expression or order is a part of the large expression statutory rule or order, meaning thereby the order has to be a statutory order emanating from either the legislature or it ought to be passed under a delegated legislation. Merely because bitumen is under an administered price mechanism of the oil companies cannot mean that the increased cost of bitumen can be said to be on account of fresh law or statutory rule or statutory order. During the course of arguments, the counsel for the petitioner was put a query as to whether the increased rates of bitumen are notified by the government as statutory rule or order. Mr. Sandeep Sethi fairly stated that he is not aware of any such position. At this stage, I see from internal page 6 para 2 of the award that the fact of the matter is that when rates of bitumen are increased, the same are not notified in the Gazetteer, and which notification in the Gazetteer necessarily happens in the case of coming into force of a statute or a statutory rule or a statutory order. The counsel for the petitioner has very strenuously canvassed before me that the respondent has accepted certain awards of arbitrations whereby the arbitrators had given the increased price of bitumen by holding the same as falling in clause 10c. Firstly, those awards are admittedly not of the present arbitrator. Secondly, in my opinion, unless there is a judgment of a court which would have confirmed the interpretation as stated by the arbitrators holding that price of bitumen is statutory order of the oil companies, I am not bound by such awards. Stop. Thank you.